Mention.
Which is when mentioning
Item 1.
May I please, Lordship?
and
The appellant obtains the charge,
there are two appeals, yeah,
two appeals, Lordship.
arising out of the same impugn order.
Same.
There are two accused, yes?
Yes, Lordship, same case.
Sudhanshu and Saroj Pradhan.
Correct.
Okay.
Sudhanshu Sankar Mishra is a government employee. By the time was working in the supply department and also still continuing.
What are the offences?
Offences plus allegation is 6 quintal 58 kg of rice plus has been black marketed.
Acha.
That means the supply people has been Soros, the other appellant in the other case. And charge was framed under section 7 of the EC Act.
Sentence?
Sentence is was 3 months.
3 months,
And to pay fine of 500.
3 months plus 500.
Default imprisonment being 15 days.
Hmm.
And so far as Sudhanshu Sankar Mishra
Sudhanshu is a government employee.
is government employee and still continuing at the fag end of his service career. And here as per section 15A of the Essential Commodities Act, sanction is required to be obtained because he was duly discharging his public duty at the time of offence.
Essential commodity law. Yes. Section 15.
Section 15A
Okay. Let us
of the
see.
EC Act,
Let us see.
prosecution of public servant,
Yes.
where any person who is a public servant is accused of any offence alleged to have been committed by him while acting or purporting to act in the discharge of his duty in pursuance of section 3, no court shall take cognizance of such offence except with the previous sanction of the central government in the case of a person who is employed or as the case may be was at the time of commission of alleged offence. No sanction laws has been obtained in this case to prosecute this person, Sudhanshu Sankar Mishra.
Okay. Where any person is police servant is accused of any offence.
B is important plus of the state government in the case of a person who is employed.
So now whether he was doing, he was performing his duty pursuant to the order made in section 3.
Yes,
What
ma'am.
is it? Let us see section 3.
Yes, allegation is he along with his one of his associate gone to
Let us
supply.
see section 3.
Pardon me, section 3.
Yes. Section 3. Power to control production, supply, distribution, etc. of essential commodity.
How to control production, supply, distribution, etc.
Hmm.
of essential commodities.
If the government
If the central government is of the opinion that is necessary or expedient to so to do for maintaining or increase supplies of any essential commodity or for securing the equitable distribution and availability of at fair prices, or for securing an essential commodity for the defense of India, not required in this case. Without prejudice to the generality of the powers conferred by section 1 and order made therein may provide for regulating by license, permits or authorized production or manufacture by the essential commodity. But we are the state laws. When the state government is doing this exercise,
what is fact in this case?
fact is,
How according to you, this is the duty assigned to him under section 3?
plus I along with one of my colleague,
Hmm.
plus we had gone to that particular village to distribute rice, APL rice and BPL rice. And allegation is while
You,
distributing,
you were working as what?
at that point, time was I was working as
What was your post?
deputy supply. Supply. Okay, supply department employees Sudhanshu Sekhar Behera. Paragraph 2 plus of the judgment.
Yes.
Briefly stated, the prosecution case as disclosed from the FIR is that on 1 November 1997.
There are 5 accused persons.
Yes, plus. The FPL and BPL rice was distributing by the supply department employees, namely Sudhanshu Sekhar Behera, the one of the appellant, Rajendra Kumar Behera and Santosh Kumar Barik, and the rice was given at the rate ₹2 per kg. Accused Saroj Kumar Pradhan, the other appellant loss, had taken away 6 quintal 68 kg rice.
Saroj Kumar was not a government employee.
No. Okay. He was staying with his wife in his wife's quarter, who was a A&M. And 6 quintal 68 kg of rice has been taken away. That is the allegation. By showing some cards.
Yes.
So there is a cows in the village, and all went to the house of that Saroj Kumar Pradhan. And ultimately, after the case was reported before the police station, the 6 quintal, some 58 kg of rice has been recovered from his house. But regarding the complicity of the present petitioner, is not clear from the evidence whether he has given the rice to him or not.
3 people were convicted.
Yes, boss.
What happened to the appeal of Narahari Mohanto? Has he filed any appeal?
Not sure.
Because Saroj Pradhan, Sudhanshu Behera
And Narahari Mohanto.
Narahari. Is there any appeal filed?
Yes, I have not verified that fact. I'm just trying to.
Anyway, we'll see that. Because Narahari Behera was 60 years that time.
Yes.
60 years at that
In
time.
2000.
97.
Might have
He's no more.
died by now.
It might.
Now
Now
it was a lordship fine and order where
88 years old.
Solicitor State
Minute.
has come to the notice that he's no more.
No more.
No rather.
Okay.
And Sarpangas, who is the prime witness, has turned hostile in this case.
The second next appeal is of Saroj Pradhan and Narahari. Narahari died. Okay. Okay. Yes.
Altogether, 16 witnesses have been examined on behalf of the prosecution. And plus, the points have been formulated at paragraph 5 of the judgment.
Yes.
Whether accused.
No. The 16 witnesses, those who are official witnesses, those who are private witnesses.
Unless they're out of whom PW3 also will get it. Page 3 of the judgment, paragraph 4. And only this judgment is visible because regarding the statement of the witnesses, depositions, they're not clearly visible. Some are absolutely not readable even. 10 and 11. May I take lawsuit to PW1?
PW1 is the informer. He has stated that.
Statements are legible. Just see, come to PW1.
Yes, PW1. Then PW1 tried to develop his statement.
What does he say?
That People one is, I know all accused persons. On 1/11/1997 in supply department mobile van, these accused persons, that's Rajendra Sudhamsila, had to sell rice. So Rajendra was the supply department. Along with Sudhamsila had to sell rice.
He has been acquitted.
They were selling rice rupees 2 per kg, and that was the BPL rice. They were supplying rice after verifying the cards of the consumers. At the spot, that is at about 12 noon, I was present. I found accused Saroj Pradhan gave some consumer card to accused Sudhanshu Behera, and he issued rice to Saroj Pradhan after verifying all the consumer cards. Seeing this, I entered inside the van as to why accused Sudhanshu gave much rice to Saroj Pradhan. There was a card in the name of my mother, Parvati Bindani. I found my mother not taken away, taken in rice in that card, but 16 times rice was supplied to her through that card. That the villagers from accused Saroj Pradhan. Accused Saroj Pradhan had kept 6 quintal 50 kg of rice in his house. The Sarpanch was present when rice was recovered from his house. On the next morning, we reported the matter at the police station. Police seized rice by Exhibit 1 in my presence. Then it is not a fact, here the contradiction is not a fact that I have not stated before police that accused Sudhanshu gave 6 quintal 56 kg of rice to accused Saroj after receipt of the cards.
But he gave on the basis of the cards which was given, shown to him.
Yes.
As against the cards, 16 cards which was given to Soros, Sudhanshu,
18
he has issued that, 18 cards. He has
18.
issued that.
We have seen the villages, but that has never been stated before the IO. The IO has confirmed the period of 16.
No, that apart, what is the case then, prosecution case?
Case is 6 quintal 18 kg.
See, Soros collected 18 cards and he gave it to Sudhanshu.
Sudhanshu.
As against those cards, he has issued rice.
No,
This is the case.
not even 18 cards. 18 cards have been seized. But there are many cards, it has been stated by
No, as against the cards,
card. He has
what is wrong in it?
Yes, he has issued
Rice.
the rice.
What is wrong in it? What is the allegation then?
But there they are saying that
The cards were false.
yes, being handed over, I mean, I have
Where is that? Where is that evidence?
no evidence to that extent. No evidence. Here, even this
So
is-
the other witnesses, what they say? This witness only says that 18 cards were given by Soros Pradhan. As against that 18 card, rice were issued by
Issued rice.
Sudhanshu. This is what this,
Yes.
and from there no case is made out.
in present.
If it is as against the what you call he doesn't say that the entitlement is 2 kilo and he has given 5 kilo anything of that sort. So there is no offense as such in so far as PW1 is concerned. Next,
Yes.
come to
One has also developed. Paragraph 4 of P 16. I will take a lot to that part.
now let us see let us understand what is the case is about.
And so far the P 2 is concerned, he has stated nothing. I just am
What does he say?
I know the accused person on 1/11/19 at about 12, BPL rice was sent for the consumers by the mobile van of supply department. The supply staff were distributing the rice to the consumers. On each month, the BPL rice was supplying to the villagers. I was standing at the spot. In the meantime, accused Saroj Pradhan gave many cards. Market.
Many cards to the accused.
To the
Accused Sudhanshu Behera. At that time, Saroj was staying in his quarter. Thereafter, Saroj Pradhan took 6 bags of rice, weighing about 6 quintals and 50 kg rice. There were about 10 to 15 consumers didn't get the rice due to want of rice at the stock. Thereafter, we found the card of a mother of P 1 was with the accused person. Except one card, Saroj Pradhan took all the remaining cards to his quarter. Thereafter, informed the villagers. Then Sarpanch and other villagers came to the spot. Then we went to PS along with the Gramaraki. When police didn't accept our report, we returned, and again in the next morning we gave report. Police see the rice and the cards from accused Saroj Pradhan.
Yes.
Before 18 months of the occurrence, my card was lost. And the card was in the name of my father. I had given a petition in the Panchayat to get a duplicate card, but on my repeated reminder, the BDO or the secretary of GP didn't give any card to me. Before my arrival, I found some people had taken their respective rice. When Saroj took away rice, some other consumers reached at the spot, but they didn't get any rice. When P 1 attempted to take away card of his mother, at that time there was a tussle. It is not a fact that the villagers forcibly took away the registers and other articles from the mobile van, but we kept card P 1 and the remaining cards were snatched away by the accused person. It is not a fact that there was no such occurrence took place on the date of occurrence and the accused persons had not given any rice to Saroj. On the next day, police sent constable to wash the rice On 3/11/19, I was examined as police. It is not a fact that I have not stated with police that I was present at the spot.
Here
Near the
also
pad,
nothing is there.
at the time of occurrence, and Soros took away rice. And here also regarding implication of the Sudhanshu is not very clear. And against many cats, he has issued the rice.
What is the offense then? Few people have the card, but they did not get. Maybe. Suppose 1 quintal of rice was to be distributed, and the cards are many, and 1 quintal is exhausted. As against the cards which were available, he has issued.
He has issued a rice
Ashwin
in
Yes.
favor of 18 cards, but the cards were given by one person.
He might have collected it. How does it make age against the card? It is issued or not? Then, what is the offense?
That is misappropriation.
No,
because-
he has not stolen
It
the
is
card.
misappropriated, sir. If the cards are given in the village, everybody has a card. Okay, you show the card, take rice. Okay. Sometimes what happens is the supply may be lesser in comparison to the number of cards. And one man may be a dalal kind of person.
Yes,
He collected all the cards
all the cards
and
and
took the rice.
took the rice.
But it was issued against the cards. Do you say anywhere or any witnesses have said that the cards were false card?
No.
Then how can you bring the offense under section 7 if it is issued as against cards? You have to assist me.
As your lordship,
Show me any
he
evidence.
has collected some cards and taken.
Maybe that is see in the village this happens.
Yes.
But how will you bring criminal offense against you? There are many people. He must be very close to Sudhanshu.
Sometimes ସେମାନେ stock ବି ରଖିଦେଇକି ଆସନ୍ତି କାରଣ ସେମାନେ it is not possible on their part to bring back the stock. ସେମାନେ allow ବି
50 ଲୋକ ଯାଇଥିବେ ଆଣିବା ପାଇଁ 50 ଲୋକ ଆଣିବାକୁ ଯାଇଥିବେ ଅଛି 15 ଜଣ ପାଇଁ ସିଏ 15 ଜଣଙ୍କର କାର୍ଡ କାଢିକି ସେମାନଙ୍କୁ ପ୍ରିଫରେନ୍ସ କରିକି ଦେଇ ଦେଇଥିବ ତ ବାକି ଲୋକ ଗୁଡାକ କହିଥିବେ ଆମେ ଆଗରୁ ଠିଆ ହେଇଛୁ ଆମକୁ ମିଳିଲା. That might be the reason.
ସେମାନେ ଆସିଲେ ପାଇଲେନି ତ।
Maybe it's not necessary that easy to your case that sufficient rice was there, despite that it was not given.
No, that
You may be entitled. But what was the rice? Easy to your case that excess rice is issued to these people. The only thing
there
is
was card
he has
and,
Soros has collected 18 cards, and because he is close to Sudhanshu, he gave those 18 cards, and as against those cards, rice were issued.
and
It may be a immoral practice, but how can you say it is a criminal act?
the card of the mother of informant has been utilized many times, but
Where from
they
you
have-
getting? Many times.
that's
Many
what I
times.
mean.
Where have you seen?
There was
Any
a card in
any
the name
suggestion that
of informant.
the-
PW 1 minute.
PW?
1.
Okay.
Middle of the first one. There was a card in the name of my mother, Parvati Bindhani. I found my mother had not taken any rice in that card, but 16 times rice was supplied to her.
mother has
In
not
Through that card.
That has been
Through that
issued.
card. Okay.
Let's make kindly come to meeting.
As against the same card, 16 times
Yes.
issued. Okay.
But they have not taken the rice.
Hmm.
But that is rice has been issued.
Then it is Soros who is responsible. Because Soros was collecting.
So every time they are.
But how the card of Parvati Bindhani came to Saros, and Parvati Bindhani has not reported.
Yes, this is a part of it. This is one of part of it. Yes. Yes, PW 1. And who else?
Mhm.
16 times same card use, huh? Yes, next. Yes.
And everything has happened in the presence of Sarpanch, but Sarpanch has been examined as PW3 Who turned hostile?
PW3.
PW3 was.
PW1 and 2 has supported.
PW1 and 2. That's right.
Supported prosecution. PW3 hostile.
Yeah.
Yes. Next. PW4.
And
PW4,
accused Saurabh Pradhan has kept 6.50 kg rice in his house. And
Where from you are reading?
PW1.
You proceed. PW1 हो गया है. PW2, I mean PW3.
PW3 hostile, PW4.
Your entire case is on the basis of PW1 only.
Mm.
16 witnesses you have examined. Let us see which said what. Don't get stuck in one only.
PW4 has not stated anything. I know all that is possible. I don't know
PW4 is
anything.
nothing. PW4 is nothing. Not a single. PW5 is also nothing. Not a single word.
PW6 also hostile.
Let us see. PW6. What does it say?
Also hostile.
I do not know anything about the occurrence.
Yes.
PW6 goes. Huh? PW6 goes. Then 3, 4, 5, 6, 7, 9, 2 rupees.
This was given to the court orders of village
By the
Baroda.
department, accused Narahari Monti was the secretary of so and such village.
The appeal place, and there was
There was a discussion that
Sarat
Sarat Pradhan was
Telling-
selling the
rice in black market.
Rice in
black
black
marketing and with
With
convening.
convening
it is all against Soros.
at the time, accused Saroj was staying in the quarter of his house, wife Sumati Patra, who was ANM at Baroda. On that day at about 10:30 p.m.,
He is saying all against Soros. Huh?
Yeah.
Soros Pradhan, yes. 8.
and one person, the supply department was given subsidiary rice by mobile van. To the village, the cost of the rice also. The people in the Sumati Patra was staying in the government quarter. Her husband Sardan had taken.
Which again he says
Yeah,
about Soros only. PW8 also Soros. PW2. He is also saying everything against Soros. Sudhanshu, he doesn't say anything about Su.
I'm trying to read because it is handwritten. I know the accused person's occurrence took place.
These are handwritings. Witness
Handwriting.
is handwriting.
Handwritten. By the land magistrate must have took the rice from the quarter of Sumati Patra, ANM quarter, Sumati Patra, a village Baroda. Supply department.
Come to 11. Come to 11.
Yes. 6.11. So the rice was kept in the quarter of Sumati Patra, who happens to the wife of
Soros.
Sarpat. Give it. Are you over?
We read 11.
7.
11.
On 25th April 1919, I was in my present post. I was accused, I know accused Sudhanshu Sankar Mishra, sales assistant, here it is the designation. Santosh Kumar Varik, driver of our department. Accused Narahari Mohan is the ex-secretary of Sampatna, GP. Accused Sudhanshu Sankar Mishra and Santosh Kumar Varik, who are selling BPL and Nepal rice at Baroda center of Sanpatra, GP.
Sanpatra.
In that center, appeal card consumers were 324 and appeal card consumers were 375 number.
In total, 6
total 690 card holders. On 26/97, 35 quintal of BPL rice and 23 quintals of APL rice were supplied to the consumers.
to the
Supply the consumers of Baroda Center. On 30/10/1997, again they went to Baroda Center to distribute the rice by taking 22 quintals of BPL rice and 18 quintals of APL rice. Again on 1/11/97, they went to Baroda Center to distribute the rice to sell the BPL and APL rice to the consumers by taking 7 quintals of BPL rice and 22 quintals of APL rice. Altogether, the accused persons had taken 64 rice and 74 quintals of APL rice to distribute to the consumers. The salesman of supply department returned 16 quintals of APL rice.
14 quintals.
No, 14 quintals of APL rice without sale. I came to know that accused Sarosh Pradhan had kept some rice by purchasing with APL and BPL card consumers.
He is implicated.
Pardon?
He has implicated all of them.
Yes, sir.
Implicated in the sense they have gone to, I mean, distribute the rice.
You were in hand in glove with that.
Soros.
That's the reason. That's the reason the other people, one driver was there with you, he has been acquitted, and the other person, someone else was there, he was also.
Accused Narahari Mantha, the ex-secretary of Sampata GP, accused Sudhav Sekhar Barak and Santosh Kumar Barik were selling BPL and APL rice. It's Santosh Barik at Baroda Center of Sampata GP. In that center, BPL cards, again and again we have gone to that spot. We have gone on 1/11/1997, prior to that on 30th October 1997, then prior to that 26/10/1997, all gone, distribute the rice. And we have distributed and we have returned 14 quintals of APL rice. We could have given 14 quintals of APL rice. That proves all.
Ultimately, you have only one point.
Yes.
Sanction. What
Yes,
is your
sir.
answer to that? Because Soros is involved, Soros has to be, convicted. What is your answer to section 15A?
Regarding sanction one.
Huh.
Sanction here is
Because it is very clear that he was performing the
sanction is
duty
required.
as a government officer. Okay. Under section 3. Because the section 15 is very, very clear. Read section 15 now.
15A, capital A.
15
15 capital A.
What is your answer?
Prosecution.
Admittedly, you have not taken sanction.
Sanction.
Huh.
Sanction was not proper.
Sanction.
Have you read the file or not?
Yes, yes.
You tell me whether sanction you have taken
That is
to prosecute
no.
this government of officials.
Sanction had no been seized.
Don't say that I'll seek instruction. Don't say that I seek instruction. Read the file and tell me whether sanction you have taken. Then how will you get out of 15A?
15.
Read 15A. He is a public servant, there is no doubt. This is your case. And he was performing duty of section 3. I read all the evidences. He went to distribute the rice and all. And then section 15A directly attracts in his case. At least as against Sudhanshu. Do you have the book? You have?
Book is
Essential commodity. Yes.
Where any person who is a public servant is accused of any offense alleged to have been committed by him while acting or purporting to act in the discharge of his duty.
A discharge, he was discharging his duty, okay?
In
Duty
presence of
in pursuance to an order made under section 3.
3.
He was empowered under section 3 to go and distribute, sell it. Okay.
No court shall
No court shall take cognizance of any offense except with the previous sanction. Yes.
Here it is state government. So of the state government, in case of a person who is employed or as the case may be, was at the time of commission of the alleged offense employed in connection with the affairs of the state.
There is no proviso to that. you have to take sanction in any case. How the trial court deals with it? Mr. Kutkia?
Pardon me?
How the trial court deals with
Yes,
it?
sir, that is that paragraph 8,
8, let us come to paragraph 8.
page 17 of the judgment. Paragraph 8.
17,
In course of argument,
Yes. Paragraph, read.
in
In the course of argument, then counsel for defense contended that section must obtain some sort of essential communications to launch the prosecution against one of the public servant, that is 15A of essential from 15A is reproduced. Take it. So there shall be sanction, and if the public servant will prosecute in the discharging of the duty pursuant to section 3 of however, in the instant case, the accused Jacob Behra had obtained 18 numbers of consumer card at the time from the Soros Kumar Pradhan. Accordingly, he had given citizen rights to the accused Soros Kumar Pradhan. The duty of Soros Kumar to give the rights by one card, and the card must be the name of the consumer concerned. That is the mistake he has committed. That is the offense. But he was discharging his wrongly discharged his duty. Therefore, you are prosecuting him. This sanction, what is this logic? What is this logic? Instead of giving the rights to in one card, accused Sudhanshu Behra had given these rights to huge quantity to Soros Kumar Pradhan. That is the offense.
Yes, ma'am.
But he was while discharging his official duty, he has done it. Therefore, you are prosecuting him. So you should have taken sanction. As simple as that.
there the Lorraine trial court has taken a view, hence sanction is not required under 15A of the AC Act to prosecute the accused Sibo Sankar Mishra, though he is a public servant.
What do you want to say? Huh?
Whether in this case sanction is required or not,
You have to?
time.
No question of time. Simple. Read the provision, read the what? You will ask whom? PW 1. He might have died by now. The fact remains that sanction is not taken. That's there.
Not taken.
No doubt about it. Again, the fact remains that he was discharging his official duty. No problem there. Official duty he was doing. While doing official duty, he committed the crime. Okay. Third is he is a government servant. That is also not doubted. Then the analogy given by the trial court, I am not agreeing with it. If you have anything to say, you tell me. According to me, sanction was essential insofar as one accused is concerned. The other accused, evidence are there. Against him also evidence are there. Only because of sanction, he come out. And he is a government servant. And the other people are, he is a government servant.
The other
97, incident is of 97.
Yes.
On the ground of sanction, are partly allowed. One appeal is dismissed. Soros appeal is
so the PO Act can be made applicable.
No, Soros, there is no case. Soros, there is no case. Insofar as Sudhanshu is concerned, on merit, you don't have a case, except sanction. On the ground of sanction, first appeal I'll allow, and the second appeal, on merit, it's dismissed. Okay, okay. Yes, yes, Mr. Sadangi, you have been watching through VCA time, and now you are there. Which item? 9.
Will also require the help my friend.
If nobody minds, I can take up 9.
No, if anybody is there, I don't.
No, just I'm asking. I don't want anybody before 9. Anybody is there? Yes, Mr. Ponda, you are there. No. Then I'll hear.
I just want to take adjournment because Mr. Nanti is there.
Let it be there in the record. Don't worry. On the board. I'll not pass any adverse order. Don't worry about it. Huh?
This 197 problem was arising because it starts that no cognizance shall be taken. But with due respect, it has been diluted that at a subsequent stage, if evidence comes, that is how these things are happening.
Item 9, na? 9, na?
Nine.
Yes, 9. Yes.
Appellants are father and son. Father was 55 then, in 2002. 77, 80. I have no idea what has happened.
The whereabout is not known. That's the problem. They have also
I
tried.
have also
They have tried.
So, 436 millions. The allegation is like this.
What would be the age by now?
Other is 55 then.
Then 55.
So 77, 78. That's
And
the range.
the other accused is
Son.
23.
Son.
Offense?
436. I was though charged for SCST Act and 06 and others. We have been acquitted. Only conviction is 436. Sentence is 2 years.
2 years.
Judgment as he. Special Act acquitted but convicted under 148, 436, 149,
किसी देखा जाऊँ
506.
किसी देखा जाऊँ If you not visible, just see the condition.
My petition is also like this. So I have stated that in my petition, page 3, the para 5, the Lord Court will accept the prosecution case and though acquitted the appellants from the charge under the Special Act, but convicted them under section 148, 436, 149, 506, 149 of the Indian Penal Code and sentenced them.
If your appeal, nothing is eligible. Your appeal.
I don't have anything else. RI for 1 year under section 148, 506, 149 of the Indian Penal Code and further sentenced to undergo RI for 2 years and to pay a fine of rupees 5,000 in default to further undergo RI for 5 months under section 436 of the Indian Penal Code by judgment dated so and so.
Then you are convicted under 148, 436, 149, 506.
Yes. 436 read with 149, 506 read with 149.
Yes. Okay. What is this prosecution case?
Prosecution case is I purchased a land which stands in the name of my wife, appellant number 1, in the village of the informant and the witnesses. Though I tried to take possession, they never allowed me. I have examined myself at DW1 and produced those certified copies. I informed the police also, nothing happened. So the prosecution case is both of us, father and son, along with many others, went to the village in a mini truck. There we threatened the villages and set fire to thatched houses, but set to fire. FIR was lost. The informant, I read the FIR minutes. Informant doesn't know the language, who wrote the FIR or anything. He only states a nickname of my appellant number 2 and says that one house has been burnt. Nobody was named. Then the witnesses specifically, they have not said who has done it. Unfortunately, only PW2, who states that she was present when the house was burnt. In the chief, he has not stated, but cross-examination, she states I have kind of
Thanks to defense
that-
counsel.
that the-
Thanks to defense counsel.
Yes, the appellants have done it. But that can be answered so far as only 6 witnesses, I think.
6 witnesses are there.
So far as PW's, other PW's,
The
have said-
execution strength is PW2.
yes.
Let us see
But-
PW2 then.
But if 3-4 who are the eyewitnesses, they say at the relevant time, the persons whose houses were burnt, they were not present at all. So nobody has seen who has done it, as per the prosecution witnesses itself. And FIR, only nickname of the appellant number 2 is
Your
there.
presence at the place of occurrence is doubtful or what, according to you?
They don't say, my lords.
No.
My plea is because they are taking away things from my land, they have falsely
Implicated.
implicated. That is the defense plea. And that I have purchased that land, that evidence is there. So I cannot be a trespasser into that place.
Yes.
But the only question is who has set fire. There is no
For the
evidence.
purpose of 436.
Yes. There is no evidence. Excepting that PW2. FIR, my lords. FIR does.
PW2. Let us-
FIR, my lords,
FIR? Yes, FIR. This. FIR eligible. Please read it.
May I read PW2 one?
FIR.
FIR. Is there? You can see from here. It's somebody is there.
Malesu, Malik, so and so, Malik, so and
Just
so.
open. One, Mr. Sir,
16, 11, 19
1 minute. You can read better.
ଏଇଟାରେ ଅଛି ହାତରେ ଏଇଟା ଅଛି ପ୍ରାୟ 3 ଘଣ୍ଟା ସମୟରେ ଆମ ଗ୍ରାମକୁ ଆସି ମିଟୁ ବ୍ୟକ୍ତି ନାମକ ଗ୍ରାମ ବ୍ରହ୍ମ
Number 2.
ୟେସ୍ ମିଟୁ ୟେସ୍ ଆମ ଗ୍ରାମର ଗୋଟେ ବ୍ୟକ୍ତି ନାମକ ଗ୍ରାମ ବ୍ରହ୍ମପୁର ଲକ୍ଷ୍ମୀନାରାୟଣ ସାହିର ପ୍ରାୟ 40 ଜଣ ଲୋକକୁ ମିନି ଟ୍ରକରେ ଧରି ଆମ ଗ୍ରାମକୁ ଆସି ଖଣ୍ଡା କାତି ଓ ମାରଣାସ୍ତ୍ର ଧରି ଆସି ଗ୍ରାମରେ ଗାଳିଗୁଲଜ କଲେ ଓ ଗ୍ରାମର ଗୋଟିଏ ଘର ପୋଡ଼ି ଦେଇଛନ୍ତି ଓ ପ୍ରାଣରେ ମାରିଦେବୁ ବୋଲି ଧମକ ଦେଇଛନ୍ତି। ଘର ପୋଡ଼ି ଯାଇଥିବା ବ୍ୟକ୍ତିମାନଙ୍କ ନାମ ହେଲା ତୁଳା ମଲ୍ଲିକ ପିତା ସୁଆଂଶୁ, ରାମ ମଲ୍ଲିକ ପିତା ସୁଆଂଶୁ। ଏଣୁ ଏହା ଲିଖିତ ଆକାରରେ ଜଣାଉଛି। ଏହାର ତଦନ୍ତ କରି ଦୋଷୀକୁ ଦଣ୍ଡ ବିଧାନ କରିବେ ବୋଲି ମୋର ଅନୁରୋଧ। ମିଟୁର ବାପା
Mittu
Surat.
with the 40 people and burned 2 houses.
ମିଟୁର ବାପା ସୁରତ ପାଣିଗ୍ରାହୀ ମଧ୍ୟ ଗଣ୍ଡଗୋଳକୁ ଆସିଥିଲେ ଲାଷ୍ଟ
He
ଲାଇନ୍
was also present.
he was also present and it doesn't say it was read over and explained or anything. Now the evidence of PW1
He signed the Odia only.
evidence of no he cannot
He signed this thing.
the Odia
Malos Moliko. Malosu Moliko.
Maras Malik.
he says in
Malesu Malik.
Malesu. Malosu Moliko. Anyway,
Malesu.
he is PW1.
he is PW1
PW1 is Malesu Molik.
yes
Malesu Molik. Let us see PW1 reads.
I know the accused persons under that. I am a member of the community. The accused persons are Brahmins. About 2 years and 4 months back, one day at about 3 p.m., the accused persons armed with Honda, Kati, etc. came in a mini truck to our village along with 40-50 others. The accused persons set fire to the dwelling house of Tula Malik and cattle shed of Rama Malik of our village. The said dwelling house was complete. The cattle shed almost completely burned. The accused persons claim to have purchased a piece of land in our village. Previously, the said land belongs to the government. We are raising paddy, mandia, etc. on that land. The accused persons set fire to the houses in connection with the said land. I have lost report in writing at Digapondi police station. This is my report, exhibit 1, and this is my signature, exhibit 1 by 1. At the time of occurrence, I was on my land. So he was also not
You are
present.
not there.
My land is at a distance of about half a mile from the houses of Tula Malik and Rama Malik. By the time I came to the house of Rama Malik and Tula Malik, I found those houses burning. My daughter Minoti
Minabi
informed
informed me.
that
The
the
houses
houses
of
of Rama Malik and Tula Malik
Set fire.
were set fire.
Then I
Who
rushed
did
to-
it is not there.
Yeah.
Then I rushed to the spot. I have seen Surat Panigre setting fire to the houses of Rama Malik and Tula Malik. He identifies.
I have seen.
So he said
He was,
I
he was
in
there in
land.
the
He
land.
was informed by his daughter,
Uh,
and then he said,
and I have seen.
and cross-examination. I have seen Surat Panigre and Tuna Panigre setting fire to the houses of so-and-so. Surat Panigre lighted a matchstick and set fire to the cattle shed of Rama Malik. Tuna has not set fire, but he was present with the accused.
He is narrating as if he has seen it.
Yes.
Where in this
And he
first,
says the father,
he was saying that he was not there at all.
Yes.
And he heard it from the daughter.
daughter.
Okay, this is the nature of his evidence.
Tuna has not set fire, but he was present with the accused. The mini truck in which the accused persons came was parked on the road. The parking place is just about 100 feet away from the house of Rama Malik. I cannot give the registration number of the mini truck. I have been examined by police on the date of occurrence. It is not a fact that I have not stated before the police that the accused persons claim to have purchased a piece of land in our village, which we are cultivating to raise paddy, etc. The same being a government land, and that is in connection with the said land. The occurrence has taken place. Linga Malik,
Para 6 3D.
Linga Malik,
Linga Malik, Nokia Malik,
Malik and
and
myself
myself
came to the police station to report regarding the incident. We got the report scribed, but I cannot give the name of the scribe. I cannot read Odia. Linga and Nakul also signed on the report. I do not know the whereabouts of the scribe. I do not know if accused Surat Panigre's wife, Prafulla Kumar Panigre, has purchased 4 acres of land and valuable land in our village from S.B. Prasad under registered sale deed dated 26/4/96. It is not a fact that Surat Panigrai and his wife have been in conscious possession of the said land since the date of purchase. It is not a fact that we caught and carried away on several occasions from the land of Surat Panigrai and his wife, and for that they reported on several occasions against myself.
This witness is completely shaky. Next, no, PW2. Let us see PW2. Full of contradiction. PW2. Yes. I know the.
I know the accused persons and the duck. The accused persons are father and son. I am a scheduled tribe member. The accused persons do not belong to our community or to scheduled caste. About 2 years and 4 months back, both the accused persons, along with 40-50 others armed with conduct at etc., came to our village in a mini truck. It was about 3 p.m. The accused persons and their associates frightened us. We kept indoors, being terrorized. They set fire to our dwelling house, that is the dwelling house of my husband, Ramo.
They set fire to our dwelling house.
Yes.
He is Rama Malik. Okay, yes.
He says he was inside and they set fire. It was completely burnt. They also set fire to the dwelling house of Tula Malik, which was also burnt completely. Those two were thatched houses. At the outskirts of our village, there is a fallow land which we are cultivating. The accused persons claim the said land to be theirs. They have set fire to the houses and terrorized us to evict us from that land. The village consists of 20 houses. At the time of occurrence, some male members were in the village and some were absent. PW1 was present when the accused persons came. Our village is about 50 feet away from the main road. The main road at the point about the land which the accused persons claim to be theirs. The mini truck came up to the house which were set fire. Accused Mittu set fire to our house. Accused Suratha set fire to Tula's house. The accused persons and all those came along with them, kept standing there even after setting fire to the houses. They remained there for about half an hour. All those persons contributed to be there. Those two houses were completely burnt to ashes. All our belongings kept in that house were burnt. It is not a fact that my villagers were cutting and carrying away crops raised by the accused persons in their land and got the case instituted in order to harass the accused persons to deprive them of enjoyment of their land. It is not a fact that the accused persons have not set fire to any of the houses in the village. The same thing is repeated.
But this witness sounds, genuine in the sense he is not shaky.
No.
He has seen them, these people, and very
She
specific
says-
attributions made against both of them.
Yes, but in a combined reading will indicate that nobody was there. First, there are two sisters. The village 20 at the time of occurrence, some male members were present in the village and some were absent.
But where is your question that you were not present? There is nothing of that sort. Rather, he says that PW1 was present, but PW1 says that I was not present.
Yes, that's why.
PW1 himself says that I was not present.
Yes.
And the PW1 is completely,
So-
it has to be discarded, not to be believed.
If the whole thing is read together, let's go through 3 and 4. It will indicate that none of them present. One simple thing, Millers, which comes to mind, Millers. Now, none of the villages, ever any of the witnesses, they say that we tried to save the house, that we tried to.
Because,
That is
because 40,
house.
50 people, see, he says that 20 houses were there.
40, 50
40, 50
were
people
there.
came and burned the house and they were standing there for half an hour.
Yes.
Hour and 40.
Till
So
it
nobody came
became
forward.
a-
That may be another way of looking into it.
But
And they have
no
written
other
that-
person has been named. Who are those 30, 40?
How much you have undergone, you tell me.
They are associated already 3 times.
Find out undergone period. That's the best way of handling
They
it.
have.
See, these are the incident happened somewhere
99.
90,
It's 99.
99. Let us see when we are arrested. Let us see. Let us.
And 3/4 says nobody was present in the village.
How will you get over 2? 2 is.
When other witnesses say that none of them were present, and the informant himself says that he was not present, and informant doesn't say that his PW2 informed him about the accused persons.
Arrested on. You are arrested on 17/11/99. Okay. Surat Pani is arrested on 17/9/11 and me too also arrested on 17. Okay. When they got bail, let us see proceeding. Both the accused persons are on bail. When they got bail? Bail, proceeding should just see bail, bail out over.
Probably order sheet of the lunch code is not there.
হুম
on the very beginning.
না কেস ডায়েরি কোড লেখাইতে পারে
No, case there status of the accused ଲେଖା on the final form ରେ.
କେସ୍ ଡାଏରୀ ଜେନେରାଲି କେତେବେଳେ ଲେଖି ଦିଅନ୍ତି ଟୁଡେ ବେଲ୍ ଇଜ ଗ୍ରାଣ୍ଟେଡ୍ ଅର୍ ସମଥିଙ୍ଗ ଇଟ୍ ଇଜ 2020
Charge sheet ରେ usually mention, they required to mention, but they don't mention.
they have not mentioned only
Simply
arrest date
they
of
have
arrest.
said it forwarded in the charge sheet also.
This charge sheet was filed on
9/8/2000.
9/8/2000.
Yes. There also they have not mentioned whether on bail or anything.
Granted bail, on bail or one is
Nothing. There's a status of the accused forwarded.
forwarded to 18
Or similarly list them on PO Act may also. Good one.
They were all along on bail and during
Yes.
the trial.
Trial and after appeal, they were also granted bail.
That's
Because
what
bail
it
is
records.
less than 3 years automatically.
389 benefit might have.
Conviction is less than 3 years, so Learned Court also grants bail.
No, I'm just wondering during trial, it might
First,
have gone.
yes.
When they got the bail. Bail bonds are there. Judgment cover. 2/3. So,
Probably on the next day, 1911. 1911 probably.
I think next day they've got it.
It's the localers notes it, which indicates, but I don't know how it came.
It is recorded that all along they were in bail. So
Yes.
no period.
And no violation also. So you'll also,
But
PO Act. you'll also-
do you have any judgment to support PO Act 436?
SC Act is also there.
Is there? Not convicted.
Not convicted.
Not convicted. Not convicted. Only 436 is the problem.
506.
Can get 506 can be given. No problem. 436 can it be given?
Yes, because life is not there.
Can you just find out? Just tell me. I'll put it on. It's some
All right,
judgment.
all right. Because 361 mandates.
See,
That-
307 also
No.
we are giving. That's not a problem. If you have some judgment on 436,
All right.
Probation of Offenders Act, then I'll grant power.
Because before PO Act came into existence, 360 was there from the very beginning in CRP. Now 361 mandates that wherever it is applicable, court has to do it. Nowadays, it's no judgment. Recent past, it's available.
Worried about the first appellant. I'll give it. Second appellant was 23 years old. Today he's,
55.
55. Just get me a judgment. 360 judgment you give, even if not PO.
No. PO is there since by the time we joined even. 89, 90
But
PO is registered.
360 will also satisfy him.
Same thing, but the impact comes from 361.
Yes.
361 mandates that you have to apply. Courts are rather duty bound to do it. Unless you do it, you give special reasons. That is what I have read in the petition also. Here the court says they are fast offenders, but never utilize that. In my petition, I'm just going through.
And the
Judgment I don't have also.
But
All right, I will get a judgment. No issues, Milos.
get judgment, I'll put it on. You said you're junior, no problem.
No. I am every day. I'm here at your lordship's service.
Yes. No problem. Huh? If you the first item करके, huh? 11th first item करके,
11 Thursday.
first.
Oh.
No, Tuesday.
Next Tuesday.
Next Tuesday.
All right.
By the time I'll also look for it. If I'll get it and I'll let you know. Okay.
I don't think there are any recent judgments because that chapter nowadays,
Some High Court judgment you will get.
90s, it was so Apex Court also, very regularly judgments were coming because it's by then they say beneficial legislation.
Yes, this is
So that is how
particularly in
application prospective, all those judgments they were continuing.
See, one thing is very clear that there were past enmity. Past enmity was there.
Yes.
Second thing is they say that 40, 50 people came. And who are they? Not a single.
And no assault or anything, no injury or
nothing is
anything.
there. And they burned the house.
And during all this
66 months
period,
and everything.
our act also doesn't indicate any.
They are entitled to probation. Conviction is there, but
Only life, where life sentence is there, there is a prohibition. Otherwise, here it's 10.
See, what was the age in the, just see in the final form, what was the age soon? Final form, Surat Panigrahi, 1948 birth. 1948 hele, Bartan kiti din 77.
More than
Just see. And the boy was 1981.
45.
45. He must be also settled in life and all.
And
You just give me.
Schedule 1 was
Working.
then
Was now
in a probably bank employee or something. Somebody, I've seen Polypon says you lower court, learn go.
Just see if he's working in a bank, it may not have an impact on his service.
no, it's already-
May not be alive. 777. Father.
Appellant number 1.
Yes.
Then I am talking about appellant number 2. Appellant number 1 might have died by now.
The concerned lawyer is also 80 plus.
They not
He
able to
doesn't
find
remember
wherever.
anything. I tried to talk to him. He doesn't remember. None of his associates who were there was also with him. So he doesn't remember. ଆପଣ ଦେଖନ୍ତୁ ମୁଁ କହିଲି ଦେଖିବା କଣ କରିବା।
Tuesday, first item go. Okay. Welcome. Yes, madam. Item. I'll just come. You work on the 12:30. You work on the judgment of 1. With
Item 14 also I'm ready.
I'll one after another I'll guess. You would go and do other work. I'll hear item number 2 thereafter.
12.
You need not waste time. You can do other. You attend other work.
One item is there.
You attend other work because she is going to. You are ready.
12.
Item 12. Item 2 you said, na?
12. 14.
12. 14. Thank you.
देखिए ना, देखिए नीचे।
Yes, madam. Offense kono? What is the offense?
Offense is 324, 324 IPC,
Sorry?
1 year conviction only. The other alleged offenses are not there.
ACST Act also.
SST is also not proved.
1 year sentence, huh? 1 year sentence. Yes.
I have filed my written submission.
Yes.
Manner offense is, the alleged offense is that the informant lost affair that he has gone recover his dues which he had given to him by supplying charcoal to his sala. That means the accused is a Kamara by profession, blacksmith by profession, and he is used to supply charcoal to his sala. And while he is asking for his debts, the accused put a heated iron rod to his abdomen. And thereafter, he has gone to the police station and lost affair.
Yes.
According to him,
Let us, who is injured? PW1 is injured. Let us see PW1.
yes. I know the accused standing in the dock. He is a resident of village Nuapatana. I am Pano by caste, and as such a member of scheduled caste. Accused is a Kamara by caste. He is neither a member of SC nor ST. The occurrence took place about 2.5 years back at about 9 a.m. in the Kamarsala of village of accused at Nuapatna. I was supplying charcoal to the accused for running his sala. I was sometime giving charcoal on credit, and by the time of occurrence, the accused was to pay 300 rupees to me towards the charcoal supplied by me on credit. On that day, I had been to ask the accused to clear my dues. Accused was at that time engaged in his work in the sala and was hitting an iron rod. When I asked him to pay, the accused refused. When I insisted, the accused came with an hot iron rod and said, so and so pierced itself in my abdomen. At the time, I was wearing a sport and underwear. Both of those were burnt at one point due to piercing of that hot iron rod. Then he threatened me to take away my life in case I reported the matter at the place. Immediately from that place, I went to the PS.
I then narrated the incident to the person present in the PS and requested him to describe the affair accordingly. And the person then read about the incident and I signed the form. Sent for medical examination. So examination.
Prepared by the doctor after my medical examination. I was also examined by cross-examination. Near the Kamarsala, the sala of the accused, nobody's house nor any shop are situated. There is no altercation between me and the accused. After I demand payment of my credit dues, I was going on supplying charcoal to the accused for a period of 1 year prior to the occurrence. And the accused sometimes used to clear the price and at times used to pay later.
Come to 11. 11.
One line would be relevant of PW1.
PW1 statement stands corroborated with the 11.
11 is
Straight away. One wound is there, size so depth, linear on the left side of the upper abdomen. The injury was simple in nature and might have been caused by hot, hard and blunt object. The hot iron rod from. So it is simple in nature. Okay?
Simple in nature, maybe the white.
But use the
Yes.
deadly weapon you have used. So 324. 324. Okay. Yes. Caste certificate is proved.
There is no conviction under 360.
Huh?
The
Only
conviction-
324.
Only 320.
Only 324. How will you get over, madam? 1 and 11?
Yes, my lord. My lord, kindly come to.
In fact, PW 11 and para 3, he
Yes,
says
Para 3.
injury- para-
Injury noted by me. Cannot
cannot be
be caused by simple.
If a hot pointed blunt object gets pierced at the
So
particular.
that is why 324. Otherwise 323 it would have been.
Yes.
Yes, my lord. One. PW1 in his statement states that the occurrence is at 9 a.m. and reported the PS to 10 a.m. and medical examination is half an hour later, that means 10:30 or 11 a.m.
Mm.
In between, he has gone to the PW5, the scribe of the affair.
Hmm.
Let's talk to PW5.
Yes. What Fidel 5 says?
He stated nothing.
Advocate's clerk.
Hmm.
On that day under my instruction.
I was working as an advocate's class at Igiria Tahsil on that day, under the instruction of one Saranga Naik, son of Duari Naik, of son of.
Yes. What do you want to say?
Yes, madam. The accused is injured by a hot iron.
Why is
Which
it?
dressing
How,
in
yeah.
the-
That is a simple injury.
This
Simple
is
injury.
injury.
He has gone there.
At a point of matchstick, the pain is lasts for 2 and 3 hours. And the scribe of the affair states nothing that he has.
Why have you not asked this question in the cross examination? You are seriously injury or the doctor
Then
in this
when is
condition,
my
in the
injury?
nature of injury is such, he could not have gone or something of that sort.
Though my minor states nothing about pain. And similarly, 9 a.m. रे injury ହେଇଛି 10:30 ରେ medical examination ହେଇଛି. And PW 11
Is my small village here.
states that the age of injury was within 16 to 20 hours of my examination.
That seems correct.
PW1 is the injured, he states
Injury report is exhibit
that 2/3.
2 by. That-
The about 16 to 20 hours.
What is this time and examination 6:30 p.m. on 24/2/2003. Just see the exhibit. Exhibit 2. Exhibit 2. Exhibit 2. Just see. Identification mark and the black mole over so and so. Time of examination is 6:30 p.m. on 24/2/2003. Time since injury about 16 to 20 hours.
20.
So the examination has taken place
Evening.
at 6:30 p.m. not 10:30.
The occurrence took place at 9 a.
9
The
a.m.
affair was lodged at 11 a. Thereafter, he was that person was subjected to the medical examination at 6 a.
Burn wound only,
Burn.
not very serious injuries. What time requisition?
Yes, Lord.
Police requisition?
But over the page,
PW 9.
24 to 2000.
What is the age of this?
My lord, the allegation under under SC&SK is discarded only due to the investigation made by the ASI.
Oh, that's right. Right. No.
And there is no eyewitness to the
How much,
occurrence.
you were arrested?
He was
Yes, ma'am.
arrested on 26 to 2003 and
Just
granted
the
bail on
charge
12.
sheet, let us see the charge sheet. When was arrested? Just see, where is it, charge sheet? File from the phone.
My lord, he was
Arrested
arrested on 26 to 2003 and bailed on
26, 26,
12 to 2003
okay.
and
And-
get bail on 12/3/2003
Arrested on 26
to
2003.
to 2003 and
get bail on 12/3/2003.
12/3.
3. Well, 3.
2003.
Again,
So
Again?
then this is February 28th day, na?
on
2
the
days,
date.
2 days and 12 days.
Again on
This
the
is
date of
14
judgment.
days, huh?
14.
14 days. Yes, next again.
Again, on the date of judgment, that is on 18/7/2006.
18,
7/2006.
2006, yes. Bail.
And bail on 28/8/2006.
You were arrested or just simply?
You ought not have that.
My lord, when he is present at the time of judgment.
Appellant is
He must
directed to
be
release.
present during the pronouncement of the judgment. He
Judgment.
must have, during the 39-month period, he must have got the bail from the High Court without getting into the custody.
So his in-
389 benefit was not given.
so his custody.
1 year
is
sentence.
53 days.
Only
Because see the
conviction.
proceeding just see 28/8/2006.
My lord,
Considering the facts and submission made by the counsel for the parties, the appellant is directed to be released.
That's the standard order.
Standard order,
The
but
standard.
was he there in the custody?
Only 1 year of conviction is there.
So therefore, was he there in the custody or not? Just see.
my lord, case is year-old and
Huh?
the case is year-old and it's conviction of simple injury and is the only allegation against the.
No, I am talking about something else. Whether when the judgment was pronounced, you were taken into custody?
Custody, Your Worship.
No, obviously
He
not.
was not in
So then 14 days only.
14 days.
14 days only.
My lord,
I mean, well,
Yes.
on the judgment, date of judgment, he was present and arrested.
He could not have arrested since 1 year.
No,
of
389 benefit would have been given.
Okay.
Less than 3 years, then generally
That has to.
granted bail. And your year of birth is 1963.
Yes, my lord.
Then you would be around 60,
65.
65, around 65. Grant Priyo, 14 days he has already undergone, 1 year sentence. He is now 63 years. What will you do with?
Okay.
Conviction maintained, PO granted. दे दियो फटाफट लिखते काम कर दो. Yeah. The appeal is which year appeal?
2006.
2006. Incident is
2003.
because 324 has to be maintained because you use iron rod, hot iron rod.
And in fact,
Deadly
injured
weapon.
has been injured. The
Ah,
injured has
Injured
been,
and he is lucky that he survived. Otherwise, something else would have been. Yes. If you could, yes, 14. Mr. Mishra.
May I please, Your Lordship?
Yes.
Yeah, media.
Yes.
Is convicted for 307 along with 506, my lord. The
506, 307.
yes.
Hmm.
Unfortunately, one page is legible, another pen is illegible, my lord.
There are two appellants. How many appellants are there?
I am for only one.
No.
There were 4 accused persons, my lord.
All of them are acquitted except you.
The charge sheet was submitted as a
Mhm.
false, my lord.
Hmm?
Final form for a false report, my lord.
The
The
allegation
case,
is that
case found to
Against the other three.
three. Against all my lord.
Then protest petition was filed.
No protest, but the notice was issued, the complaint didn't file in protest petition. The court summoned to take
To call the-
against three persons, not me, my lord.
Hmm.
By virtue of a 390 petition, I was added and accused and I was convicted.
You have been convicted, the other people were acquitted.
No,
They were also convicted.
Faced a
convicted.
different trial since it was a part file.
Part file, my lord.
It was a part.
What happened to their appeal?
That is not
Do you have any idea?
pardon for
Hmm.
record, my lord. Nor for me.
It is a direct hearing.
It has to, Your Lordship, because through the High Court website, it is not traceable.
Not notice.
We have to
Nothing is
write
there,
the
ma'am.
details.
Neither from the district court record.
This is a your own record
convicted.
and I is not.
Okay, you have been brought in because of 319.
Yes.
390.
Let us see what is the allegation against you.
Allegation, my lord, the informant while sitting in his house, the one Ganpati Naik came along with these persons, my lord, two and me, my lord. And they shot gun towards me. Unfortunately, he escaped. And that gun shot at the wall, my lord. And these incidents seen by his daughter and wife. But they have not uttered any word against me, my lord.
Hmm.
All the allegation against one Ganpati Naik.
Who fired? Ganpati fired.
Ganpati fired allegation of the informant. The informant is alleged in Ganpati Naik because one case has been registered against him by 42. Present case is 43. Ganpati Naik is the grammar occupier. And the present informant is the Sarpanch who deals with the illegal business of the country-made gun and objected by that Ganpati Naik. The inner truth is listen to a lesson to that Ganpati Naik. The present case was registered. Therefore, the case was.
Who are you then?
I have nowhere, but I have been implicated, my lord.
He was accompanying the main accused to the place of occurrence.
Occurrence.
No, what are the evidence against you?
Evidence against me, nothing, my lord. The PWs are.
PW3 is the victim. PW1 and
Let us
2
see
the
the victim.
eyewitness.
Yes.
What does he say against you?
Yes.
Yes.
Let us see.
Victim is.
319 is invoked. There must something. You have not challenged that order also. You face the trial.
Yes.
Let us see. PW
3, Your Lordship.
3. Let us see the witness what he says.
May I read it?
That
I know all the issues.
that is the incomplete record because my lord ma get page 1, there are page 3. 2 page re kon achi. That I am reading, my lord.
Let us see whatever there.
Yes.
Yeah.
Panchu Singh Maji, my lord.
Hmm.
The informant.
I know all the questions. The occurrence took place on so.
I was sitting in a chair at the back veranda of my front house. My wife and my
All the accused persons.
My
came
wife
to-
PW1
Yes.
and the daughter PW2
2
were taking their meals
means
in the front
veranda of the back of my house. All
All
the
the
accused
accused
persons came to my
came to
house
my house.
and accused Ganpati fired a gun aiming me,
Hmm.
which hit the wall of my house, causing 2 holes in the wall.
Hmm.
And then they ran away from my house from the bari side.
I lost the written report.
I lost the written report as a Sarang
The-
PS. The report was scratched by an
Also,
Vishwanath Dole. She has not been examined.
after
Exhibit 1 is my, that is it. After investigation of the police, the page 2 is not there. I didn't file any complaint petition because I came to know that the court has sworn to take cognizance for the offense in this case. I don't remember the name.
he is
of-
talking about complaint or protest petition. He is
Yes. That was issued by 173.
Name
and
of who
that,
the-
that in the city, my lord.
Yes, I am.
I didn't remember the name of the clerk from whom I ascertained this. I am an accused in 2 to 3 cases, my lord. I am also a witness in some criminal cases. It is not a fact that I am manufacturing country gun, and for that police has raided my house several times. It is not a fact that either I have mentioned in my FIR nor I have stated before the IO that I was sitting in the back veranda of my front house. It is not a fact that the accused Jairam Paik is not a
He
residing.
has only said about Ganapati.
Ganapati, my lord.
Let us see PW1.
No,
Freedom.
Your Lordship, kindly see the last suggestions. Your Lordship.
Yes.
Yes.
It is
Did
not a fact that the accused Jairam Paik is not
No,
residing in my
that
village.
accused, last suggestion.
हाँ
Yes,
सीता
yes.
घर गाँव रे
My village.
रोज
I
Last
took
one.
up a
Cross examination by Jairam.
yes.
It is
Jairam.
not.
Please not have that I have not stated before the IO that all the accused persons came to my house and accused Ganpati fired a gun aiming at me, which hit the wall of my house, causing 2 holes in the wall, and that they ran away from my house by side.
Why is cross-examined?
Pardon, Your Worship.
This much.
Why is
That
cross-
suggestion,
Uh,
the suggestion by this particular accused, Your Worship. They wanted to, probably they
but
want,
I don't know. Page 2, 3 ଥାଇପାରିବ ନା କହିଥିବ ସିଏ।
maybe, Your Worship.
କହିଛି,
In the
ସେଇଥିପାଇଁ ପଚାରୁଛି।
TCR also page 2 is not available.
Maybe. Because page 2.
They wanted to take
Let us see,
plea of alibi.
see, there are 2 eyewitnesses,
Yes, yes.
basically, wife
That-
and daughter.
Wife
Let us
and
see what,
3 eyewitnesses, one is the injured and the wife and the daughter.
let us see who is injured.
That is
PW3.
3 matter, my just read.
W3.
He is an informant. He is not
Injured,
not
nahi,
injured.
not
He is the
injured.
victim.
It was
I
aimed
stand-
at him.
I stand corrected. He is the victim.
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 He is not in true sense
Injured.
victim in the sense he is not injured.
Probably he was the
It was
target.
aimed out to him.
He was the target.
Yes, target was. Let us see.
PW1.
eyewitnesses.
PW1.
And he was a armed dealer.
Yes.
There was enmity between
Definitely.
Ganapath and him. That was
Ganapati
there.
Naik,
He
Ganapati
said,
Naik is
I'm not dealing with, it is not the fact that I'm dealing with the arms. He says that I'm not dealing
But
with it.
somehow it has come.
that will be found from.
Let us see. It is one.
Suggestion given to the, which was denied.
Purnavasi Maji. Yes.
Yes, sir.
Their wife.
I know all the accused persons. The occurrence took place about 1.5 years
What was?
back
1.5 year back.
on the
in
Monday
one-
at about 8 p.m.
I, along with my younger daughter Sabita, were taking meals on the front veranda of the Barry side. My husband, namely Panchu Singh Maji, was sitting on a chair in the Barry side of my front house veranda. There was a courtyard between the place where we are taking our meal and the place where my husband was sitting. Accused Ganapati Paik, followed by 3 others, naming only Ganapati Paik. 3 other accused persons came with a gun from the Barry side of her house.
TCR টা আছে।
Accused Ganapati Paik had a gun aiming my husband. The bullet hit the wall of my house and didn't strike my husband. They all of them left my house through the Barry side.
Yes.
Then who is the missing man? It is a fact that on 1972, my husband was booked in a criminal case on the allegation that he fired a gun to a Saura minor. And it is not a fact that my husband is an illegal dealer of gun. Accused Joram Paik is a man of Jerango, and he has a house in my village. But he resided in the house of one Sabar Paik of my village. Our village is not electrified. It is not a fact that it was not a dark night. It is not a fact that accused Joram Paik is residing in Raigada.
May I pray? Worship?
Nothing is said on
Your Worship, the entire TCR is missing. Every second page is missing, Your Worship, including judgment also. So that TCR
No,
only.
no, judgment judgment copy is legible.
It is out of a design or
No, probably they have missed it.
2 is not a legible.
From all the
judgment-
evidences, second pages are missing.
here also third. Here also third. PW2.
No, I have taken the records from here only, so that is why I'm at par
Second
with
page is
you.
missing everywhere.
Almost
My lord can have a
Nahi.
glance to the judgment, my lord. Judgment is legible. Hard copy.
Judgment will be.
Only judgment is clear.
The judgment is clear, but see, because you have been implicated through 319.
19.
So let us understand what evidence has come against you.
My lord, whole case
And
is-
all the 3 witnesses are saying that Ganpat has done it.
all are related.
And these people,
Yes.
you were there. You
Yes.
were there. There is no doubt about it. You were there. That is why you cross-examine. Nobody has taken your name. What is the overtake played by these people are not coming.
It's not coming forward.
Nothing is there.
My lord,
There is no overtake played.
if she is saying, my lord,
The second page of the depositions are missing. Maybe they have stated something.
From the judgment, can we get anything?
nothing, my lord, I have gone through. Well, if she is able to recognize that Ganapati Naik, why not others, my lord?
They have one to one. They stated that I know all the accused persons and
Yes.
accused persons. All
But what is their role? They may be knowing.
You should
What is the attribution to what role they have played?
He accompanied the main accused to the house of the informant. That is how 34 come into play. That is enough to settle a conviction.
My lord, one more
It is
thing, my
not
lord.
public place that he is a chance person to be there. They, along with the Ganapati Naik, who fired at the informant, they went inside the house, they fired and they came back.
Anything recovered from them? Anything?
Nothing, my lord. There is cash filling in the belly.
All
What is
accused person.
The
General
pellets-
statement in 307.
The pellets were recovered, Your Lordship. The 2 pellets recovered from all of the informant. Your Lordship.
that pellet, my lord? I am saying, my lord. On the last night, that informant shot gone to a snake, my lord. Therefore, another 2 pellets are in the mango tree and another tree, my lord. That is in the CD, my lord. A joint supervision report is there, my lord. The page 61, my lord, of the
The
TCA.
cognizance is taken against Ganpat only,
Ganapati and other 2, my lord.
not against you.
No. But there is the allegation of a use of gun, my lord. Law and Code below to cognizance of only 307 and 506. No 27 Arms Act is there, my lord. And the whole story is that attendant to kill by means of a gun, my lord. That gun is not there.
Recovery of gun from the possession of the accused is
Recovery nahi. My lord,
not mandatory.
kind of glance to the MOs, my lord. Only 2 pallets.
It is not mandatory for recovery of a weapon of offense.
Kind of glance to the page 61 of the TCR, my lord.
Pellets were stuck in the wall.
Wall, my lord.
One in the wall, one in the tree.
And another 2 from the mango tree. And have shooting, my lord.
Where is that?
Achhi, TCR is sabu achhi.
Habit of shooting.
Yes,
Evidence to nahi, beyond evidence.
TCR achhi, my TCR achhi.
PCR mane court.
Page 61 supervision report.
Supervision report is a part of the trial. They have given a suggestion that informant was dealing with the arms, which was denied by the informant. And there are 3 eyewitnesses, including the and they have not examined any person to show that the plea of alibi allegedly taken by this present appellant.
What is the role played by him? Except,
Your Lordship, he accompanying to the house of
but
the
he,
informant.
it is also not said that name is not taken, accused persons.
No, Your Lordship, they say.
And particularly when closure report was filed
Yes, sir.
and cognizance was not taken, 319,
as
what are the substantial evidence?
No protest petition filed, my lord. No notice was served. And all of same village.
He is not filed.
PW1, PW1, who is the wife of the informant, who is the eyewitness to the occurrence. I know all the accused persons. Then they say accused Ganapati Naik, followed by 3 accused persons, came with a gun from the bari of our house. Accused Ganapati.
That's why, madam, closure report was filed.
Your Lordship,
Thereafter, even against 3%,
yes,
2% against 2% cognizance was taken.
3%.
Cognizance was also not taken. Against
Lordship,
him.
that is why
No protest petition is filed.
protest petition is
319, unless specific allegations are
overturned.
there,
Yes, Your Lordship.
how can you bring?
Lordship, now we are on conviction. So
That's
3-1
what I'm wondering. What is the role played? Except general statement that all the
it is
persons.
general statement, Your Lordship.
Yes, nothing is.
Lordship,
Na-
PW1.
No overtake is attributed.
Lordship, no overtact is needed since he is booked under 34. The moment he accompanied to the house of the informant, that is enough to bring home the.
Also not coming forth.
34, my lord, that PW1 doesn't know about his name, my lord. Only saying followed by 3 persons.
They say, I know all the accused persons. So, had it been a case that he's from the outside, they don't know anyone, so naming them would be necessary.
The 4 year sentence, madam, unless the evidence is there properly, we can't.
34 is there. 34 and 506 is there.
And we don't know what happened to Ganpat's appeal also.
I'll try to find it. Mr.
Find out.
I'll
see,
try to find it.
the
So I was
sentence is-
trying, in fact, from the NIC website, nothing is there. Since it is a year-old appeal,
and
My-
this-
my sister
para-
is
all page two of witnesses
they're
are not
missing. They're
there. We
missing.
don't know. In the page two, they might have
There
said
might be,
anything.
might be.
Because 319 is once it is invoked by the trial court, unless there is fee,
Some
unless
materials
some
are there.
specific role is.
He would not have entertained. That
Obvious,
wouldn't have
because
entertained.
because the trial court in the first instance has not taken cognizance against this man,
This man.
taken cognizance against other two persons,
Rest 3 persons, Your Lordship. Yes.
Ganpat and another 2 persons.
Ganapati
Two
is
persons.
2%.
My lord, my sister is asking about that habit of shooting, my lord. PW8, my lord. The IO.
Hmm. What does he
It's
say?
category settled.
He filed closure report.
Yes, my lord.
Hmm.
I visited my lord PW8. That Prafulla Kumar with the IO.
Yes, yes.
May I read, my lord? I examined the witness at the police station and then proceeded.
Where are you reading? Which paragraph?
Paragraph 1, my lord.
Hmm.
I visited the spot. I didn't prepare any spot map. I seized of a mango tree. Ambo gachare have bullet marks, matter. Said to have bullet marks. Kanthari bhi thila, ambo gachare thila. I prepared the seizure list. I examined the letter witnesses in village. Then I see the 2 pallets from the wall. PW seizure list in present witness. MO1.
Seized 2 pallets from the
Wall.
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 Of the house?
ଆମ୍ବ ଗଛରେ ବି ସେ ଆଣିଛି ସେ ଲାଷ୍ଟ ନାଇଟରେ ଗୋଟେ ସୁଟିଂ କଥା ସାପକୁ ମାରିଥିଲା ତ ଶୁଣିକି ଦିସ୍ ଅଦର 2 villages came to his house and they were assaulted, my lord. Therefore PS case number 42 was lodged against this informant. And,
That 42 case is exhibited here.
yes, my lord. There, I have not submitted charge sheet in this case because this case was being supervised by SDPO. He has opined that this is a false case. The supervision note that the SDPO has opined this case is a false. The supervision note is not available in the record. I am filing this supervision in original in the court today. The supervision note has been given to my officially and not privately. I brought the supervision report from the office. I have not taken any permission from my. It is not fair that I have fully neglected to my duty in recording that the correct statement of witnesses. The cross-examination, I have seen firing mark in the mango tree standing in the barrier PW3. PW3 has a. She is saying, my lord. I examined PW2. It is a fact that PW2 has not stated before me that the accused Ganapati came to her house and fired a gun, aiming her father. It is a fact that PW2 has not stated before me that after firing the gun, accused Ganapati went away in the Bari side. Further, the bullet strike the wall where her father was sitting.
You find out, madam. You will find out. Because IO is completely shaky. So he has filed a closure report of his. You find out, I'll give the witness look. Give the witness look. Huh? No. Give the what's the issue?
Most important, 307 allegation there, madam. 307 allegation, the attempt was made by the gun shot. That gun is not in the picture, my lord. Therefore, no arm shaft is there, my lord.
The pallets were recovered.
But that
in the wall.
no arm shaft is there, my lord. Only cognizance taken 307 and 506, my lord.
34, because of 34 you are there, minus 34 you are not there. Let us see page 2.
Yes.
If you can.
Yes, sir.
The original record I am see, yes.
No.
Huh?
Maybe it can be retrieved.
Look.
My lord, all numbers are there, even numbers are not there.
I'll just see. From the scanned copy of the evidences placed before this court, it appears that the substantial part of evidence are not scanned. Therefore, the trial court record is treated to duplicate the evidence. The registry is directed to make sure that the entire transport record is summoned. On the Thursday. Next Thursday. Court reader?
Additional session judge Parlakamandi. Okay. But that record
Entire record I am calling.
25 at the other so far with regard to other accused persons matter.
Let us see.
We'll try to ascertain in the meantime.
He will
25
civil asserting. Okay. Written note of submission submitted by Mrs. Mishra. Taken on record. Yes. Yes.
The date is
গোটে সপ্তাহ পরে রাখো রেকর্ড আসিব না 13 পরে না 13 পরে 18 রাখো if I'm parallelly the entire record will come so let us wait you wanna do it?
Item 31st, Petition Miller for interim bail. Can have a glance of the order dated 16/10/2025. And Miller on that day, my lord directed to State Council. Sohra also take instruction regarding the Miller custody certificate
And the criminal
as
act.
well as the criminal. In fact, Miller, 2 persons convicted and my lord granted Miller bail for interim bail is co-accused. Miller.
Yes, similarly report we have asked for.
Can I pray for some more time, Lordship? I've written the letter. Just follow it up and get to you.
Because see the co-accused has been granted bail on the basis of a
Yes, sir.
report. So
Yes,
therefore I
sir.
thought there's some report.
Lordship, can I just
Then-
pray for
Then
some
how
more
much
time?
time?
1 week, Lordship.
1 week, huh?
One.
Next Sachil. Next Sachil.
On 16 my lord, this is Udine Wood. Also taken.
1 week, no?
Matter be, so it
The order.
take some time.
See, by order dated 16/10/2025, a report was sought from the district superintendent of district jail Balangir within a period of
Regarding the custody certificate.
within a period of 1 week, regarding the custody, regarding the antecedent and
Antecedent will be called for from the local police station.
a report was sought,
A report was
sought, which has not been furnished by the concerned officers. Therefore, also for the state seeks 1 more weeks adjournment. Lease the matter also.
Next thought,
Lordship,
Next Thursday. 18th or
Yeah.
13th or 18th?
can I pray for 25th?
Okay, 25th.
25th, much of it.
25th. So that you will not take adjournment.
Yes, sir, because the criminal action has to come from the,
By Vakula. Yes. Yes. 15. Yes. $94 matter pending. Yes.
In this case, the
Yes,
appellant
sir.
has
Hmm?
challenged the judgment and order of conviction passed by the additional session judge Sambalpur in ST case number 146 of 29, madam.
Yes.
And the conviction was
307.
This one.
3 years.
3 years, madam.
PW3 is the injured,
Hmm?
And the-
PW3 is the injured, 1 and 2 are the doctors.
And the
Injured is 3
PW3, your Lordship.
3, madam.
PW3 injured.
And madam, the informant is
1 and 2
chief
are the
father.
doctors.
And PW3 and
speaks.
PW 1 minute.
1 and 2 are the doctors.
PW
1 and 2.
and 2 doctors.
Yes,
Doctors, PW injured, and PW6 is the informant, madam, his father.
PW 6 informed. Let us see PW3 first.
And madam, this.
and injury report, your
PW
Lordship, exhibit 3 and 4.
Okay, let us see PW3 first.
Yes, ma'am.
Injured. What does he say?
And I am pressing. I know the accused in the dock. I used to stay in quarter number 56 of Orient Paper Mill Colony at Vadrajanagar. Accused also stay in the same row of quarters. I had previously given a pant piece to the accused. So the accused was due to pay me rupees 40 on 19 to 92 by 6 p.m. I asked the accused to pay the money. The accused picked up quarrel with me and paid 40 rupees. On that night around 8 p.m. while I was returning from the market near H line colony, the accused suddenly came and stabbed me by knife on my left abdomen.
Left abdomen.
Yes, sir. While the accused was giving the second blow, I caught the knife, so I sustained injury on my left palm. I sustained bleeding injury. I raised south.
Then abdomen and left palm. Okay.
Left.
Certain bleeding injury. I raised south. Taking the accused so stab.
I sustained bleeding injury. I raised south, saying accused who stabbed me.
One Murli was standing. Murli is PW.
It is scissor. William PW 8. Murali Patra.
Yeah.
But he was not there, madam. He has admitted
Therefore,
no
went
one is
to
there.
Jasuda and therefore.
I proceeded, I sustained bleeding injury. I raised shout saying accused Shambhu stabbed my knife. One Murali standing near the pawn shop. Pawn shop came there. He was standing in the pawn shop now. I told him when then I proceeded in a vehicle which was coming from the side of the clinic of PW1. Their doctor PW1 gave me medical aid. Then I went to ESI hospital. Therefrom I went to Jharsuguda. Therefrom I was sent to Burla Medical College Hospital. I was hospitalized as an indoor patient for 19 days. I can identify the knife by which I was stabbed. MO is the said knife at the place of occurrence. Strict electric light was then glowing. Cross examination. I knew the accused for last few years. I used to sell cloth pieces. I was examined by police. Now this is the important. I was examined by the police, but not relating to this case. Some boys were playing at the.
Where the boys were, I was examined by police,
but not relating to this case. Some boys were playing at a short distance from the place where at first the accused picked up quarrel with me. By the time of stabbing, I was alone. And no one was there. No one was the eyewitness. It is not a fact that the accused stabbed me, but due to business rivalry, I think. The knife, like MO1, are available in the market, but I recognize the same out of the metallic.
Come to one. PW1. PW1 injury. Doctor.
PW1 murder who treated the accused murder victim. I am a private medical practitioner having my clinic.
Belly injury in belly.
It has one incised injury of size 1/2 into 1/2 situated between the belly and the chest of left side. The injury was probably caused by cutting and pointed weapon. It was simple in nature. This is the important one. I examined the patient about it. The injury was fresh. I gave necessary medical aid. The injured told me that he was stabbed by one Shambhu. The
injury was sufficient to cause death of a person in ordinary circumstances. So even if it is simple, 307 can be invoked. Yes.
Thereafter, madam, in cross examination, she has stated that. Come to fifth line, madam, cross examination. The above injury can be caused due to fall on a piece of glass having pointed edge. It is also admitted. Thereafter, madam.
PW2
Who is
would be.
2?
PW2 matter, the CSI hospital, he simply stated that as he is not eligible to get a treatment, I refer to Bulla. I will think so. I advise to shift the patient to other hospital. Jehetu se government
The
hospital.
condition of the patient was serious, therefore he was referred to.
Refer to the Bulla hospital.
Then my lord, I have.
Why should these three witnesses will be doubted?
Madam,
Injured witness and
madam, I'm coming.
Including your
Thereafter, madam.
6 and 8.
Madam,
You were immediately there.
FIR, which was lost by the informant. He has not scribed it. The scribe is a different person, and that scribe has not been examined by the prosecution. And Murali has stated, my lord, as per version of the
8 PW8.
PW8.
Right.
I knew the accused in the dog. I was as a governor of Mumbai. He has stated at page 37 now. 37.
Separate.
Paragraph 4.
You read examination
He is
sheet.
not a trustworthy witness. And because
1 minute, trustworthy. Let us see. At the time, PW3 came running
Yes.
and told me that the accused Sambu has stabbed him by knife. And I found the accused was
Yes,
coming
told.
from
The
knife
accused
and
told some stab.
knife was stained with the blood, and the accused was coming from so-and-so line and so-and-so, so-and-so. Yes.
Therefore, my lord, this witness, my lord, paragraph 4, I am entangled in 3 criminal cases.
Well, but then merely because he is involved in 3 criminal cases, his evidence has to be discarded.
No, my lord, that has to be not, he is not trustworthy, my lord. As
Because he was involved in 3 cases.
he is a stock witness, my lord. As because police has,
And what about the doctors?
yes, doctor has said it is the injury is simple and it may cause on falling of a piece of.
Oh, those.
That suggestions are always.
That's always that suggestion.
Thereafter, my lord, at paragraph 4.
Is it your case in 313 you have said that he fell down?
There is nothing on record to
There is
suggest that
suggestion.
even.
You have not suggestion also.
In 4, my lord.
That suggestion is not given to
Hon'Ble,
in.
ମୋର ସରୁ ତାପରେ ଆପଣ କହିବେ ମଝିରେ ଆପଣ କହିବେ ମୁଁ କହିବି ସାର୍ କାହାକୁ ଶୁଣିବି
Kudu.
ଏମିତି କଲେ କେମିତି?
Yes. Paragraph 4 you are reading.
Paragraph 4, that MO has not been produced, but I don't find the same in the court.
Which paragraph? 8.
PW8.
Okay. I cannot identify the seized knife. I do not find the same in the court.
Court, my lord. That has not been identified. Thereafter, my lord,
Come to 6.
28. And the my lord, 28 page, the informant.
PW6 you are talking about?
PW4.
4.
I was in my house at that time. 2 boys came. Told
Where are you reading?
Sambu, my lord, PW4.
4. I was in my house, yes.
2 boys came and told that Sambu stabbed my son PW1. So I then went to the clinic of PW1, found there was bandage on the belly of PW3. We were advised by the doctor PW1 to carry my son to the hospital. My neighbor scribed the report, and after understanding the contents, this scriber has not been, and who has scribed, that has not been also been disclosed, and he has also not been examined. Who is the neighbor of the. Thereafter,
Sorry, PW5?
No, Bishop, kindly reread the PW4.
Sorry.
No, wait. PW5, yes.
PW5. PW5 is important now. I know PW3, so also the accused in the dock, about a year before an evening.
Yes, he told.
Right. On an evening between 7 to 8, told that the accused stabbed at his belly. I found blood was coming from the abdomen. I carried the PW.
You post occurrence.
Paragraph.
He is a Caesar witness.
Paragraph 2, cross-examination. I was not examined by the police. I cannot say where from the knife was brought, I have not read the with the contents of the Exhibit 5. I cannot say what has been written. It is not a fact that I.
Recovery is doubtful.
Yes, ma'am.
Yes, P6.
6, ma'am.
Some altercation taken place between them, and I asked the accused Sambu as to why they were quarreling.
EW since he is the elder brother of his father. My kindly come to page 33. The father of the injured, paragraph 2, page 33. The father of the injured is my elder brother. Paragraph 2, page 33. The accused paid 40 to the injured, but I have not counted the money. I was not examined by the police. The place of occurrence is a busy place. After payment of money, I went to my house. And he is also not stated the concrete picture.
These are minor contradictions.
Minor.
The fact remains that you attacked. Fact remains that he was injured in
fact
very.
is that matter,
Hmm.
there is a quarrel. And out of it might have been happened. And my humble submission is for you also. At that time, the accused was a student and he is 21 years old. But the
Come to the point.
Yes, ma'am.
Come to the point. Real point is this.
Yes,
Hmm.
ma'am.
Real
And
point is this.
he is the first offender. So he should have been got the availed the benefit of minor PUR.
No, you are. What is the type? What was your age that time?
21.
Let us see. Is
20 or 21. The first offender. That was in the judgment also, madam.
no. What is the age? Let's see. Final
Page
form.
8, verse
Final
20.
form.
And the
final form now. Fire में नहीं लिखा होगा.
The time of judgment in 1994,
चार्जशीट
verse 20.
है ना चार्जशीट. हाँ रखा है.
judgment रे लिखा है जी हमारे 22 years.
Come to चार्जशीट sir.
चार्जशीट मुझे ना
चार्जशीट अच्छी सब होती चार्जशीट देखो. ये तो देखो
से
चार्जशीट.
पढ़िए कोई से. Another thing is that madam, the prosecution.
1 minute. Let us see understand what is the age charge sheet. क्या क्या पता है. चार्ज शीट लगाइए. चार्ज शीट लगाइए. चार्ज शीट और शीट. आप मुझे
I have got some judgments on this matter.
tell me the age.
He was 22
There is the
1994.
judgment also.
90,
He was 22 in 1994.
94.
94.
And then now must be about
25,
55.
25, 6.
yes. What judgment you? Regarding what?
You see,
Yeah, I'm gonna- Judgment. Don't mind.
Yes. Regarding what? For 9.
regarding what judgment Ramesh Chandra Sahu and another, it is 307 is altered to matter 324 matter.
Yes. You see, the facts are different. What had
No,
happened
you
is
see
the
the-
intention. I'll tell you why intention can be imputed to you is first in the evening there was a quarrel, and thereafter in the night when he was coming you attacked. That means you have
At that
determined
time
to,
also there was a quarrel.
determined to
It
attack.
is in the record, on the
It's
record.
not a sudden and
PW6 exactly says that.
Hmm.
He
Huh?
witnessed it.
No, no.
PW6
It-
He exactly says that.
My lord,
He
it is
witnessed
there,
what
my
he
lord. It
witnessed.
is there. There is a quarrel at the time of.
No,
There was a dispute.
but it was in the evening it has happened.
ସେତେବେଳେ ବି ହେଇଛି.
Huh,
ଟଣାଟଣି ହେଇଛି.
therefore, intention was
At the
there.
time of intention also, the stabbing there was also. a
Then
quarrel.
why he was carrying the knife? Because there was a
Yeah.
quarrel in the evening.
My lord, the knife is also in dispute, my lord.
It
It
is
is
not-
also recovery of knife is also disputed. The seizure witness whose knife was seized, he refused, my lord. That was also not confronted by the prosecution.
No, PW8 and the victim, you know, they both say the knife was seized.
That has not been confronted. The seizure witness refused. That nothing has been seized in my presence. I have not known the contents of the seizure list.
And that knife has been.
That has not, whether that has been confronted or not, that has not been confronted by the IO, to the IO. So how
May I place it?
it is uncertain.
भाई सरला
नहीं सर.
नहीं तो सारण तो मैं स्टार्ट करी.
Thereafter, my lord,
One minute,
another-
judgment I am reading.
yes. 307 ingredients has not been established by the
1 minute, let me read the judgment.
Yes.
In this case, bad head ticket is proved.
My lord?
Bad head ticket.
No, my lord. That has not been proved.
These are facts to facts, different nature of injuries and all. The judgment will not directly help you. There is no principle laid down in
And
the
the my lord,
no, why for you are relying? The judgments are nature of injuries are different, the facts are different, evidence is different. There is no
yes.
there is no principle of law
Our
enunciated here.
Our High Court doesn't that.
Huh?
Our High Court doesn't that's
The High Court means what are the principles?
In
Nothing.
that case, prosecution witnesses
And
never
the
supported.
307 ingredients has not been proved by the prosecution. My first
Why?
leg of argument.
Why?
Madam, the MO has not been seized. The medical ticket has not been proved. Whether how many days he has undergone treatment.
See,
That is
the doctor
not
who is
there.
referred, referral doctor is examined, and the doctor who is
And the informant itself, my lord, he has stated in his cross-mention, I was not examined by the police. The informant itself, who happens to be the father of the victim injured, he has stated that I am not examined by the police.
yes.
And my lord, my last leg of argument is that my lord, the present appellant is the first time offender and he was at that time was a student, and that's why he
But
should
the FIR is named FIR.
he has been named in that.
It was registered when?
And another thing is
Only
that
see Dui.
in his
The incident happened on. Incident happened on Onishi Dui. What time?
the doctor also said that the injury is simple. And
That's-
another thing is that, my lord, at the time of recording
date of occurrence is
statement of the
20.
accused,
Hmm.
the circumstances which has not been put to the accused specifically that cannot be used against him. That is there, my lord, in the those circumstances has not been put.
Which one?
At
313.
page 20, my lord. 213
Yes.
is the referral accused statement.
Which circumstances? All the circumstances are put. ₹40 was asked for. Thereafter, there was a quarrel, and
After
thereafter, in
questioning-
the evening when he was coming, you attacked. That's all. These are the incriminating materials. Everything is put. Everything is put. Mujani nahi, mujani nahi, mujani. Yes, madam.
So, first of all, the knife which has been the weapon of office that has been exhibited as MO1.
Caesar witness didn't support.
Pardon, Your Worship?
Caesar witness didn't support. I said
No,
the
no,
knife was shown to
only
the doctor.
Yes, Your Worship. That has been shown to the
Let us see.
Madam,
PW?
that ballistic report is not there. That has not been examined.
ballistic report
Knife-
knife record was Sibo.
Knife has not been examined, madam. That has been brought before the doctor. Only suggestion was given. That is the important factor. Knife
No, no,
examined.
is there.
Madam?
It is produced.
Worship, page
MO1,
24,
MO1
the
is the
witness is verifying.
state knife which is produced before me.
Yes, sir.
Doctor says.
Madam, kindly have a glance to that.
After my examination, I have
Yes, sir.
that group.
leveled with my signature. And the witness stated that verifying the herger and so and so, so and so. It was produced before the
It was
doctor.
before.
Madam, whether that has been sent to the chemical examination report? Nahi seta. You.
Not needed.
But
When
that
the
is the
injured has been
So many
examined.
things could have been done. Prosecution
No,
could have been
that
done.
is- that is
But
the
now
one-
today we are examining whether the evidence which has come, is it enough for 307 or not?
Yes, yes.
So many things could have been done.
Yes, yes.
Over and above this, many things could have been done. He could have been booked for arms act also. So many things could have been.
It
That,
is the
that has
minimum.
not been done. But
Madam,
how will you doubt these
It
witnesses?
is the.
That's the question.
All these witnesses who have been examined, there is no independent witness. First thing, there.
1 and 2 are the
Three is
witnesses.
most dangerous thing. 307 is much more dangerous 302. Because you have killed someone, he has gone. But 307, the
injured is
secured is
survived.
the witness. And if he says that I have been attacked, I got received injury in this part of my body, that part of body, that has to be seen
Corroborated by
corroborated.
doctor and that is.
Doctor. There is no enmity with you insofar as the doctors are concerned. Two doctors, referral doctor
Yes,
says
Your Worship.
that I have referred it.
Doctor-
Injuries are serious.
Madam, the referral doctor has not seen that particular injury. He only said that there was bandage.
Your
referred-
last argument, you said that you were 21 years
First
and
offender.
hot blooded that time. He then did it. Now he's in late
Even the victim
50s.
was 21.
And he has already
The victim was of 21.
Other young boy.
already has served murder 5
Ah.
months.
You tell me that. That's enough.
He was arrested on 10/4/1992.
Arrested on?
10/4/1992.
1 minute. Arrested on 10/4/92.
92. And
Bail
released on bail
23/9.
23/9/92.
23/9/92. So, कितने
5 months, 13 days.
5 months,
13 days.
13 days. And after conviction?
He filed appeal matter.
3-year conviction. So
3 years.
must have got the 389.
Let us see. Right. It's like-
से High Court miscase number 70 of 1994. He was granted bail on 24/2/1994.
No. That's there. That's there. So 5 months. What is the sentence?
3 years.
days.
Let us give probation.
307 is there.
307 probation.
And the injured.
Direct judgments are there. 5 months he has already undergone.
5 months is on that.
Remaining period probation. Because 307 probation judgments are.
Assume.
It's not a case for acquittal. Not a case for acquittal.
ଆଉ କୋଡିଏ ଦିନ ଆଉ କଣ 4/2/94. From the miscase, it shows that he was in custody while preferring the appeal. It's
While
true.
preparing the appeal.
हाँ.
Where is that? एक मिनट.
Mentioned in the miscase.
एक मिनट. Just see the वकालतनामा. He the Vakaratnama.
Dr. Anju.
He was in custody.
He was in custody.
He was in custody.
He was in custody.
When the appeal was filed while custody, because see the Vakaratnama is signed by jail authority.
Even
In custody.
তাহলে bail ହେଲା କେବେ?
24 to 94.
Sentence କେତେବେଳେ ହେଲା? Sentence
4 to 94.
4
4 to 94.
judgment
4 to 94.
4 to
94.
94.
24
Bail order is I'll tell you.
24 to 94.
Bail order is 24.
Right.
24 to 94 bail order. Order. Let us see the what you call the bail bond when he is furnished bail bond. So 20.
Belwan nale 23 na 92 ରେ ତଳପଟ ଦେଇଥିଲେ।
24 to 94.
This now which is the first time it. 94.
bail bond वही और नहीं है क्या bail bond? देखना bail bond नहीं है। और है क्या?
ऊपर लेके तो डेट है।
Still 20 days here.
20.
20 days. Let us take 20 days.
So 5 months, 23 days.
20 days. After conviction.
6 months.
6 months.
13 ଦିନ ତାପରେ
6
20
months, 3 days.
6 ମାସ 3 ଦିନ 6 ମାସ 3 ଦିନ।
UTP 5 months 13 days 20 days. So 6 months total
3 days.
6 month 3 days. ठीक है जी. Rest of the period provision.
The judgment କେତେ ଜାଣି
These judgments are not applicable.
it is
I'll refer to because you are arguing. I'll refer
they have not also proved the prosecution has not failed to establish the case their case merit. Seizure witness support करना तार बेड हेड टिकट प्रूव हुई है तार इन्फॉर्मेंट निजे को जी आई वाज नॉट एग्जामिन्ड बाय
You tell how,
Once
why should I
statement and
why should I
actual evidence.
disbelieve injured witness and doctors evidence?
And even PW 600 is the rest just eyewitnesses.
Look, no further deliberation. Every day फटाफट खत्म करो। ठीक है कितना लगे? 3 का कितना 7 दिखा है तुम्हें 7 दिखा है तो दिखा है हाँ 7 दिखा है बहुत अच्छा दिखा है धीरे धीरे पता आई थिंक यस हाँ देखिए फटाफट करो ये नहीं पियो
Sir, item 23.
23 offense
326 millions.
326 undergone
सीधी रखी दे दो अंडरगॉन मिला
28 na 20
23 मिला
undergone period
6 days.
6 days undergone huh PO what is the age of this both of them
Weapon of 51.
incident relates to year which year 92
92 मिला
that time these people were just take it up
appellant 1 is 61 years old currently appellant 2 is 51
now is 61 years
A2 is 51
51 years what are the injuries
Injuries, your lordship, in this case, your lordship, though is the conviction 326 for array for 1 year, but weapon offense is showed, your lordship. And
1 year is sentence
yes, your lordship.
6 day undergone
Yes. Amputated fingers, your lordship. in
that
this
is
case.
because the version of PW10 who's the injured his version has not been completely believed by the court in the judgment my lord
so therefore what kind of injuries which part of the body
my lord injuries are there are 3 injuries one on his thigh there's a cut injury on his ear there's a cut injury
And there's another cut injury in which 3 of his fingers.
Vital part there.
Yes, yes, that time I'm saying objecting pure your lordship.
Well,
But-
who vital part is
Yes.
where?
Your lordship, that is the
High.
neck, your lordship, neck, your lordship.
Neck. He says
Neck.
that
Not no,
here.
here, sir.
Mysore assaulted neck, your lordship.
Who is the doctor?
Doctor is PW, PW 10 injured, PW 13, your lordship.
13.
Yes.
Let's see. Sharp cut, chopped wound, resulting in amputation
Yes.
of left
Finger.
pinna. It is a complete amputation.
Lord.
But the trial court says, not believe.
Lord's trial code at para 14 of the trial code judgment. Lords. Admittedly, PW10 and accused persons are related to each other. There is also evidence that land dispute between PW10 and accused Dhaneshwar and Maheshwar was going on at time of incident. In my view, it cannot be a ground to discard his evidence. However, I hold his evidence needs vivid scrutiny and corroboration.
Going through the details of evidence of the evidence that the accused Dhaneshwar assaulted, severely injured him by means of a sword.
Has not been discredited, hence I hold him a reliable witness. One of the accused persons was acquitted, my lord, Sarveshwar, at para 16.
Para
16 minutes. One of the accused was acquitted.
Surveyor is concerned. I find that PW10 is simply has stated that the accused obstructed him. On the way, PW10 does not say that. The PW10 that she, let us read PW10. What does he say? Surveyor has participated fully, but he has been acquitted.
He has been acquitted because Sarveshwar had no role in the incident, but PW10 had.
No, he had cut hold of the motorcycle,
Which has
it
said that
obstructed. Thereafter, the assault was made.
But the done a trial court disbelieve the part concerning Sarveshwar, to which PW10 had deposed. Para 38 of the trial court judgment will.
That's right, but it partly be not believed. Para
38 minutes.
8.
The evidence relating to the act of accused Sarveshwar is not consistent. Para 41 also, my lords, kindly. After going through the entire evidence on record, including the medical evidence, nothing appears to me that any of the accused persons attempted to cause the death of PW10. The circumstances of the case, including the act of the accused persons, do not suggest that the act was done with such measures as would be constituted the act of a murderer. or act of a murder if death has occurred. The doctor PW 13 has stated nothing that any of the injuries were sufficient to cause death in ordinary course of nature, nor there is any evidence in this regard. The medical evidence does not disclose that any of the injuries were cumulative dangerous to life. Hence, it cannot be said that prosecution is successful to establish case under 307.
Yes. What do you say? Why PO is not?
Your Lordship, here is the case, there is the PW injured and that too, there is an eyewitness, 1, 2, 4 and 11 are eyewitness to the occurrence and clearly supported the case.
Therefore, conviction. You just simply tell me why PO should not be invoked.
The
In
next
view
one
of
for injuries and weapon of offense used, that is my whole submission. In order to that the police appellants are not deserved to go on the PO act on the ground, the weapon of offense used and the nature of injuries sustained in the body. Therefore, the appellants are not entitled to give the PO act.
but PW 13 says that it is not so dangerous.
Simple,
what it
but
Then-
those are simple.
Therefore,
but weapon of offense
307 is
sword
converted to 326.
That is there, Lordship. But so weapon of offense sword is used and one finger is amputated and there is a neck injury also.
There
But
is
what
no
is
neck
the
injury.
neck?
There is no neck injury.
Yes, PW 10.
Come to PW 13. Where is
Yes,
where does he say that it is so dangerous?
because working in the pediatric specialist in the Patamdi upper PAC on that day on police requisition.
But how much fine is imposed? Fine?
There is no only punishment, conviction is 1 year. There is no fine. We will enhance to fine, then there is no section to that. Only conviction for 1 year.
No fine is imposed. Huh?
No, there is no fine imposed. Only conviction for 1 year. Amputation ହେଇଯାଇଛି 2 ଜଣ appellant ଅଛନ୍ତି ଏଟାକୁ enhance କରିକି lots of exam I know.
Maheshwara Sahu, Dhaneshwara Sahu.
Bhaneswara,
Yes. The fine has to be imposed. But there is a dichotomy. I wanted to just ask you also just examine this issue. I'm doing in couple of matters. I did it. Suppose you substantive sentence for substantive sentence. Suppose I give PO. Okay. And in the same time, I'm saying that you pay fine also. And there should be a default sentence. In the substantive sentence, I'm letting them on PO. Default sentence, how can I send him to jail?
For defaulting, that cannot be.
So then, what will be the use of this fine? There should be a default sentence.
Yes.
And how will you treat that default sentence? How will you execute that one? Suppose he will not pay.
Then he has to. then
How will you
the
treat?
that has to be recovered.
See, in this case, 1 year sentence.
Yes.
1 year sentence, na? 1 year sentence.
Yes, sir.
So I can, up to 6 months, I can go in for a default sentence. Is concerned.
Yes.
Suppose 1 month default sentence I'm giving.
Yes.
PO, substantive sentence, PO, no problem.
Yes.
If he doesn't pay 10,000 rupees or 5,000 rupees, whatever I impose,
It's a different. He has to get arrested in case it is not recovered in the deed.
then for substantive sentence probation, but default sentence he has to undergo.
Yes. Sir. That is what happening in when only fine is imposed. That
It's not only fine. Both the sentences are, I'm maintaining the sentence.
maybe, Your Lordship, but
That's the problem. There is a big problem there. But I'm doing it, but it is practically not executable in true sense. You will not pay. What do you do? What will you
get
do?
arrested.
Nothing. I will do it like that. What to do? See, these are the matters of 1996. The incident taken place in 1992. Now, situation is changed. Let us see. Is it the- I'll increase the fine. I'll impose fine and the provision. Okay.
5,000 is fine.
5,000, 10,000, 20,000, we'll see. Two people are there. Let us see. And see, one body part is imputed. See the seriousness.
That is the reason I.
Very serious this thing. It should have been 307 basically. You should be happy that I don't know why these people have not that part of equitable part. Surveyor, they should have challenged because see, injured says he is obstructed thereafter the blow has
Blow was-
he has given the blow. Dhaneshwar has given the blow. You should have challenged that.
That part, that one.
Not challenge.
Challenge.
Okay.